Hi, I'm Mitzi Hill. I'm a partner with Taylor English Student in Atlanta. I have been a technology lawyer for nearly 30 years, including both in-house and as outside counsel. And in my current role as the head of the data privacy and security practice at Taylor English, I work with companies on their privacy compliance obligations and on planning for security, data information security that may be related to those privacy compliance obligations. Connecticut is one of the many states that have passed and enacted a comprehensive consumer privacy law. It went into effect July 1st of 2023 and is one of the first handful of laws to take effect in this area in the states. And it covers a wide range of activities by the covered company and gives the covered consumer a wide range of rights, including the right to access, correct, or delete data that has been collected about them, the right to opt out of profiling, like for marketing purposes, and opt out of the sale of their personal information, the right to opt in if a company is processing sensitive data about them, the right to opt out of automated decision-making, which is sort of algorithmic targeting behind the scenes. And it requires covered companies to behave in a certain fashion when they're collecting data, including giving very explicit notice of what they collect and how they use it, being very transparent about that, conducting what are called risk assessments. So in other words, figuring out where their data collection practices might have the potential to harm consumers and then adjusting for that, and imposing a limit on companies about what they collect and how they collect it. In other words, what they collect has to be related to what they're going to do with it. You can't just collect anything you want. The final thing about the Connecticut law is that it institutes a broad definition of personal information, which is sort of a hallmark of these new style privacy laws. Connecticut, like the other similar state laws, covers a wide range of data about any individual consumer and offers the consumer all of those rights and imposes on the company all of those obligations in respect of any of that broadly defined personal data. Connecticut's law is enforced by the state attorney general, and the attorney general is authorized to institute fines or levy fines of up to $5,000 against companies for violations of the law. They also can seek to enjoin or stop any behavior that they find is in violation of the law. And they can, unlike in some other states, the financial penalties can also include the attorney general going after what is called restitution, meaning if a consumer has actually been harmed, the attorney general can seek to have that consumer made whole, or disgorgement. So if the company is found to have profited illegally off of its privacy violations, it could be forced to give back those profits. Connecticut's approach to privacy enforcement is a little bit different from some of the other states, including in the fact that it was one of the first states to require a specific opt-in to allow processing of personal data. Most states don't require consent for most collection or use of personal information. And this was one of the first instances where a state made that a requirement. Another way that Connecticut's law differs from some of the other state privacy laws is that it specifically requires that by the middle of 2025, all covered companies must honor what's called a universal opt-out mechanism, which is essentially a browser setting that allows consumers to tick a box or toggle a switch that will opt them out of all of these covered activities in various states without having to customize for each state. I'm Mitzi Hill. I'm with Taylor English in Atlanta. And if you have thoughts about the Connecticut privacy law or questions about the way that it might affect your company's operations, please feel free to get in touch.